You've already talked about how important it is for the Commission to engage in research activities. We've had some discussion about technology and how fast those advancements are moving. What are the challenges or impediments to the Commission best fulfilling the mandate that they have to promote responsible innovation?
Thank you for the question. Yes, I think Congress had the foresight in 1974 when the agency was created to include in the statute a research and information program. I would say that that language is slightly outdated now and could benefit from an update. I mean, technology was very different in 1974, and the task was very different in 1974. So, to the extent that the committee would seek to update that, I think that's worthwhile. As to impediments, there have been occasions when the agency would have benefited from obtaining information from the private sector, because when we talk about technology, the private sector is where the most beneficial information would be for the CFTC to conduct this research. And there are occasions when federal procurement laws has prevented them from doing so.
Part of it gets to the definition of a gift. We most oftentimes think of a gift as something of a monetary value or a physical item, when technology, the definition there. And so I want to move to you, Mr. Schwartz. My colleague, Congresswoman Chris McDonald-Rivett, and I, we introduced the CFTC Research and Development Modernization Act to rewrite the CFTC's mandate for research and development activities. Specifically, it modernizes and hopefully will future-proof the Commission's research and development mandate, provide an opportunity for the Commission to create a new research and development plan. How might clearer requirements, definitions, and authorities around this mandate improve operations of the Commission?
Well, to pick up on something that Commissioner Stump said, the language is 50 years old now, and it authorizes or directs the Commission to have a research and information program about things like determining the feasibility of using computers for trading. Now, I think we're all satisfied that it is feasible. The Commission has moved on. But it would be helpful to have a clear mandate to tell look, the Commission would always rather have clear direction from Congress to execute rather than to, set the mission for itself and make sure that it doesn't cross any lines. The appropriations issue is very, very important. So I think all involved would appreciate that kind of legislation.
So I'll stay with you, Mr. Schwartz. No other regulator currently exercises authority over entities registered with the Commission, such as futures exchanges, clearinghouses, or FCMs, for activities subject to the Commodity Exchange Act. If a state regulator were able to unilaterally determine that a transaction was subject to state law, what would be the consequences of state regulators also exercising concurrent jurisdiction over an exchange, a clearinghouse, or an FCM for that transaction?
That's a question that was asked back in 1974, and Congress answered it with exclusive jurisdiction for the CFTC. You would have a patchwork, and that's probably too generous, of 50 states in the District of Columbia regulating activities that occurred on, for example, a designated contract market. I don't think it's workable.
Those are my questions, Chairman. I will yield the 1 minute and 5 seconds back. Thank you.
Very good.